Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Point Sources, Pollutants, and Groundwater Edition. I'm your host, Grace Gotchling. On November 6, 2019, the U.S. Supreme Court heard County of Maui, Hawaii versus Hawai'i Wildlife Fund, a case which involves a dispute over whether the Clean Water Act's permit regulation applies when pollutants originate from a concrete point but are only conveyed to navigable waters indirectly via groundwater. Under the Federal Clean Water Act, the CWA, someone seeking to discharge a pollutant from a point source, such as a pipe or well, into navigable water must first obtain a permit via the National Pollutant Discharge Elimination System program, known as the NPDES. The County of Maui, Hawaii, owns and operates 4 wells at a wastewater treatment plant that processes several million gallons of sewage per day. Treated wastewater from the plant is injected into groundwater via these wells, and some, ultimately, enters the Pacific Ocean via submarine seeps. Hawai'i Wildlife Fund and various other organizations filed suit against the county, alleging that it was violating the CWA by discharging effluent through groundwater into the ocean without an NPDES permit. The district court agreed with the plaintiffs, and the U.S. Court of Appeals for the Ninth Circuit affirmed, rejecting the county's argument that no violation occurred because the pollutants did not issue directly from the point source, the wells, into navigable water, the ocean, but rather traveled indirectly to the ocean via groundwater. The Ninth Circuit's reading sharpened a split among the Federal Circuit Courts of Appeals on the proper interpretation of the CWA, and the Supreme Court granted cert to address whether the CWA requires a permit when, quote, pollutants originate from a point source but are conveyed to navigable waters by a non-point source, such as groundwater. And now, to discuss the case, we have Glenn Roper, attorney at the Pacific Legal Foundation.
This is a very significant environmental case, and most of our listeners are probably familiar with it. But I'll first provide a little bit of background, then I'll discuss what happened at the argument. I plan to generally go more or less sequentially through the argument, but I'll try to identify common themes as they emerge. So first, as to background, this case involves the scope of the Clean Water Act, and that act requires a federal permit for, quote, any addition of any pollutant to navigable waters from any point source. The question in this case is whether a federal permit is required when a pollutant is discharged from a point source, not directly into a navigable water, but into groundwater that eventually seeps into the navigable water. So just to quickly summarize the facts, Maui County owns a wastewater treatment plant that disposes of millions of gallons of treated sewage into underground injection wells. By design, the wastewater mixes with groundwater at the bottom of the wells and seeps through the aquifer toward the ocean. In 2013, the EPA conducted a study where they added tracer dye into the wells, and they were able to eventually identify about 2/3 of the dye emerging into the Pacific Ocean about half a mile from the treatment plant. It took an average of about 15 months for the dye to reach the ocean. So in light of that test, a coalition of environmental groups sued the county under the Clean Water Act's citizen suit provision for operating its wastewater treatment plant without a federal Clean Water Act permit. Circuit courts are divided on the right way to handle this specific question, and they've applied at least 3 different tests. First, the Ninth Circuit in this case held that Maui County was required to have a federal permit. The test it applied is that a permit is required when, quote, pollutants are fairly traceable from a point source to a navigable water, such that the discharge is the functional equivalent of a discharge into the navigable water. Now, I've never been quite sure whether that is one test or 2 different ones, and as we'll see, some of the questioning showed that justices weren't entirely sure either. Second, in a different case, the Kinder Morgan case, the Fourth Circuit agreed that there could be liability for discharges to groundwater, but it applied a different test, concluding that a permit is required if there is a, quote, direct hydrological connection between groundwater and navigable waters. And then on the other side, the Sixth Circuit disagreed with the Fourth and Ninth Circuits and held that federal permits are not required for discharges into groundwater, but are only required for pollution that makes its way to a navigable water by virtue of a point source conveyance, essentially the position that Maui County argues for in this case. So as we can see, there are three different tests proposed by the circuit courts, and much of the oral argument in this case before the Supreme Court focused on what the proper test to apply is. So let's go ahead and turn to oral argument. First, Elbert Lynn, the former Solicitor General of West Virginia, argued the case for the county. He emphasized a couple of things in his opening remarks. First, what is at stake is not whether Maui County's disposal of wastewater is regulated at all. Everyone agrees that a number of state and federal environmental programs apply. Rather, the question is whether it is regulated under the Clean Water Act's point source program or under its non-point source program. Second, Mr. Lynn emphasized the county's textual argument, which is that the Clean Water Act's definition of point source as a conveyance shows that the key question is not where a pollutant comes from or originates, but how it reaches navigable waters. So in the county's view, you look at the thing that actually delivers a pollutant into the navigable water. If it's a point source, then a permit is required, otherwise it's not. And then third, he emphasized the importance of predictability. Given the strict penalties for noncompliance, regulated parties should be able to know in advance whether they have to seek a permit. And several of the justices picked up on that point in later questioning. So Chief Justice Roberts asked the first question, and in fact, he was the most active questioner throughout the day for both sides. He began by trying to pin down the county's test, asking whether it means that any intervention of groundwater between a point source and a navigable water makes the point source program inapplicable, whether the point source is just leaking pollutants into the groundwater or forcefully expelling them into the groundwater. And Mr. Lynn agreed that any intervention of groundwater would make the point source program inapplicable. He held firm to his textual argument, where you just look at what delivers the pollutants to the navigable water. Justice Breyer then took up the questioning, and his primary concern seemed to be whether the county's test would allow polluters to evade permitting requirements by redirecting pollution into groundwater. In his typical pragmatic fashion, rather than parsing the text of the Clean Water Act, Justice Breyer was focused on, as he put it, finding a standard that would prevent evasion. The county's position, in his view, would provide, quote, an absolute roadmap for people who want to avoid point source regulation. That is, they could just end their pipe or other source of pollution before reaching navigable water or redirect it into the groundwater. And that was his concern. Justice Kagan picked up on that same concern, asking whether the county standard would mean that, quote, nobody would ever have to go through the process of getting a permit if they knew that they could just do something like what Justice Breyer was suggesting, stop the pipe 5 feet before the ocean. In responding to that concern, Mr. Lynn disagreed with using the term evasion, going back to the fact that even where the federal point source program doesn't apply, other state and federal laws do. So redirecting pollution into the groundwater isn't a way to avoid regulation, and he in fact cited Hawaii laws that would prevent the exact hypothetical of cutting off a pipe shortly before a navigable water. Justice Sotomayor jumped in at that point, expressing concern that the county's position presumes the state will regulate, but that some states don't. And she here seemed to be echoing comments made in a brief filed by the state of Maryland and several other states, making that exact argument, that some states regulate differently or more forcefully than others. Now, Mr. Lynn responded that there's no serious concern that states will just allow what he called a Wild West, where there is no regulation of point source pollution. He listed 3 reasons for that. First, the Clean Water Act requires states to have a non-point source management program. Second, there are millions of dollars in grants and incentives that encourage states to regulate. And then third, the Clean Water Act has a water quality backstop where it requires states to report on water quality. Now, at that point, the discussion and the argument turned to the text of the statute. In a complex and important statute like the Clean Water Act that uses defined terms like point source and navigable waters, it's a little surprising that much of the textual discussion instead focused on a simple preposition, the word from. The county argues that because pollution has to be added from a point source, which is defined as a conveyance, a pollutant only qualifies if a point source is what conveys the pollutant into the navigable water. That's what the county argues from means here. Now, in contrast, the plaintiffs have argued that if a pollutant is discharged by a point source and ends up in navigable waters, regardless of what happens in between, then it is from the point source. Now, Justice Kagan, in getting to the text, she really echoed the plaintiff's argument, saying, quote, "Here it's from a point source, which is the well, and it's to navigable waters, which is the ocean, and it's an addition. How does this statute not apply?" And as to the specific word from, Justice Kagan generated the first laughter of the day by asking whether the plaintiff's argument wasn't a normal way of reading the word from. In other words, to decide, these are her words, to decide whether something is from something else, you have to look at whether it's from something else. Justice Kavanaugh chimed in, indicating that he thought both sides made good arguments as to meaning of the word from. And he asked Mr. Lynn what other tools the court should look at to decide which interpretation to go with. Mr. Lynn pointed to two things, the structure and the context of the Clean Water Act. As to structure, he argued that the plaintiff's position would essentially read the non-point source program out of the statute, because most things are initiated from a point source. If they end up in navigable water, under the plaintiff's position, that's good enough. As to context, he reiterated that the Clean Water Act imposes harsh civil and criminal penalties that can total more than $50,000 a day. In light of that, he argued Congress would be expected to impose requirements that could be determined in advance by looking at the conveyance, rather than basing liability on an after-the-fact analysis of traceability. Justice Alito was the final justice to chime in during the petitioner's presentation. He expressed concern about whether there's any limiting principle to the plaintiff's position and expressed doubt as to whether their standard can be found in the text and is workable. But because those questions really go more to the plaintiff's position, I'll talk about those in a moment. So after Mr. Lynn presented his opening argument, the second attorney to argue was Deputy Solicitor General Malcolm Stewart for the United States. Then the United States submitted an amicus brief in support of the county, but it made a slightly different argument. Rather than looking at the conveyance that actually gets it into the navigable water, the United States argument might be described as the groundwater is different approach. Put simply, the United States argued that Congress intended that groundwater breaks the causal chain, such that a permit is not required for pollutants that enter groundwater. Mr. Stewart put forth what is probably the most memorable example of the day, the whiskey example. He said, if I at my home pour whiskey from a bottle into a flask and then bring the flask to a party at a different location and pour whiskey into the punch bowl from the flask, nobody would say that I'd added whiskey to the punch from the bottle. In contrast, bringing the bottle to the party, if you pour it from a few inches above the whiskey or through a funnel, in ordinary parlance, we wouldn't say that simply because there was some spatial gap between the bottle and the punch, therefore I didn't add it from the bottle to the punch. So in his analogy, the flask would act as groundwater, and if you have that intervening flask or groundwater, you wouldn't say that the whiskey was added to the punch from the original bottle. Instead, you'd say it was from the flask. So under the Ninth Circuit test, he argued, the whiskey would be traceable to the bottle even if it went through the flask, which can't be what Congress intended. Now, several of the justices asked Mr. Stewart about the limits of the United States position. The chief began by asking whether any little bit of groundwater is enough, even 2 inches of groundwater. And consistent with his bright line position, Mr. Stewart agreed that even 2 inches would be enough. However, under the United States view, if the pollutant travels over land instead of through groundwater, then permits would be required. And that seems to be the major distinction between the county and the United States. Justices Kagan and Sotomayor asked Mr. Stewart about the possibility of evasion, that same concern that had been brought up with Mr. Lynn, asking whether his position would allow parties to avoid permitting just by putting pipes directly into the groundwater. And like Mr. Lynn, Mr. Stewart for the United States focused on the other statutes and state regulation that apply to groundwater. He emphasized that the point source permitting program is not intended as a cure-all, so it's okay if it doesn't apply in every situation. Now, Justice Kagan quarreled with his argument a little bit, responding that the plaintiff's position, which he appeared to support, would still leave a large sphere of activity that the federal government is not touching. It would just mean that when the federal government permitting program applies to point sources, it applies to those point sources regardless of whether it goes 2 inches underground. Now, Justice Breyer asked the final questions to Mr. Stewart, and here he laid out what I think appears to be his proposed approach, and it's kind of different than any of the other standards. Justice Breyer seems to want to give the EPA maximum flexibility to write regulations setting the rules for what is covered. So rather than the fairly traceable position adopted by the Ninth Circuit, he focused on the second part of the Ninth Circuit's test, which asks whether a discharge into groundwater is the quote-unquote functional equivalent of a direct discharge into the navigable water. So Justice Breyer asked Mr. Stewart, what if we set that as the standard, whether it's a functional equivalent, and then let the EPA conduct rulemaking to decide exactly what that is going to mean. Mr. Stewart initially expressed some skepticism about what that test might mean, but ultimately agreed that if the United States had rulemaking authority and could flesh it out, it would be helpful. So that was the end of the United States argument. Finally, David Henkin took the stand on behalf of the environmental plaintiffs. He focused in his initial remarks on the fact that the text of the Clean Water Act doesn't include the word directly. That is, it doesn't just prohibit discharges directly into navigable waters, but all discharges to navigable waters from any point source. As to the meaning of the word from, he used a different example, the example of groceries. And he said, quote, when you buy groceries, you say they came from the store, not from your car, even though that's the last place they were before they entered your house. He also explained that the EPA had interpreted the Clean Water Act consistent with his view for 30 years without the parade of horribles that the county argued about happening. And finally, echoing some of the earlier justices' questions, he noted the potential under the county's argument for evasion by large-scale polluters who could just put their pipes into the groundwater. As with the other two lawyers, the Chief Justice was the first to ask questions, and he focused on asking what is the limiting principle of the plaintiff's argument. Now, Mr. Henkin pointed to two things, traceability and proximate cause. Now, the Chief took issue with both of these supposed limitations. As to traceability, he talked about that being just a technological issue and a question of how sophisticated the instruments are that can trace the pollutants. So, as a reminder, in this case, the EPA conducted a tracer dye study where they put dye into the wells, and then they were able to trace those emerging into the ocean. So the Chief was concerned that because it's just a technology issue, that's not going to impose a significant limitation. Now, as to proximate cause, he called that notoriously manipulable and asked whether the plaintiff could provide any examples where pollution is added to groundwater that makes its way to the ocean, but where there would be no liability due to an intervening cause. Now, I don't believe that Mr. Henkin fully responded to that question, as far as I can tell, but he did cite a case where the EPA concluded that discharges from a mine where it would take them 60 to 400 years to get to a navigable water, that was just too far, and that would cut off the causal chain. At that point, Justice Ginsburg jumped in to ask about the Fourth Circuit test, which asked whether there is a direct hydrological connection between the discharge and the navigable water. She asked Mr. Henkin what he thought of applying that test. Now, Mr. Henkin explained that he thought his test is narrower because it includes the concept of proximate causation and foreseeability, not just whether there is a factual connection. Justice Alito responded at that point, questioning whether there's any practical difference between the two, and he asked whether there's ever a case where there is traceability but not foreseeability. Now, Mr. Henkin essentially conceded that's correct, that there's no distinction between traceability and foreseeability in this context. Now, at that point, the discussion turned to an example that featured prominently in the briefs, and that of septic tanks. Justice Alito asked whether an ordinary family out in the country that buys a septic tank, following all the appropriate permits, could be liable under the Clean Water Act if 10 years later the septic tank starts to leach pollutants that make their way to navigable waters. Now, Mr. Henkin first argued that a properly installed septic tank wouldn't discharge pollution at all, but both Justices Alito and Gorsuch pushed back on that and tried to nail down a straight answer as to whether a homeowner could be liable if it did leach out of a septic tank. Now, Mr. Henkin's response was, again, to focus on traceability, stating that where you have one septic tank, you'll usually have multiple septic tanks in an area, and if you can't trace pollutants back to a particular septic tank, then no permit would be required. At this point, Justice Breyer jumped in again. He echoed concern about whether the plaintiff's test is just too broad and would put all kinds of people in the position of having to get a permit. He stated that the plaintiff's proposed traceability and causation tests, quote, seem to say the sky's the limit. And he again here suggested his functional equivalence test, where the court would announce a broad functional equivalence standard and then let the EPA write the rules. Now, Mr. Henkin agreed that his side could embrace that test. At that point, the Chief Justice jumped in and vigorously questioned what the functional equivalent test would actually mean. He argued that it was just as vague as a fairly traceable test and wouldn't add much clarity or certainty. At that point, Justice Kagan stepped in with what I view as some friendly questions about how traceability would apply to septic tanks, and whether the inability to trace pollutants back to a specific septic tank would mean that regular homeowners just aren't at risk of liability. Now, there was some vigorous back and forth between Justice Kagan and the Chief Justice, even at some point talking directly to each other and skipping over the advocate about proximate cause and how that would work. For example, the Chief Justice said, well, I think it would be worse if you had 100 potential polluters with septic tanks, but you're saying in that situation, you wouldn't have traceability, and so you wouldn't have any liability, whereas if you had just one homeowner with a septic tank, you would have liability. And Justice Kagan tried to help the advocate by talking about, well, isn't that how proximate cause generally works in a variety of situations? After that colloquy, Justice Kavanaugh broke in. He reiterated concerns about the cost of the permitting programs and about whether the plaintiff's position would lead to uncertainty and transforming the federal-state balance. He here emphasized the citizen suit provision of the Clean Water Act and how that can put parties at risk even if the federal government isn't seeking enforcement. And he emphasized that the standard needs to be something that's objectively clear on the front end and not just something that you figure out of a lot of litigation. Mr. Henkin tried to assuage his concerns by indicating that to establish his test, the traceability and foreseeability, you really would need a big discharger, not a small homeowner. Justice Alito ended the questioning of the plaintiff's counsel. He asked a number of questions and went back to the whiskey example here and thought what I consider to be a very good point, asking about whiskey, and he said, well, to extend the example, would you say that the whiskey came from a barrel in Scotland or wherever the whiskey was initially formed or distilled? That reminded me of a thought that I had about Mr. Henkin's grocery example. And you'll remember that he said, if you're interpreting the word from, if you go and buy groceries and bring them to your home, you would say that the groceries come from the store and not from your car. And I think you could ask the same question that Justice Alito did. Well, you may say they came from the store, but you wouldn't normally say they came from the manufacturing plant or from the farmer's field or from another source. Just making the point that really it's not as clear as I think Mr. Henkin would like to have it. But first, this may be a good time to open up about Mr. Lin's rebuttal piece. He took questions primarily there from Justice Sotomayor, who vigorously asked about or expressed concern about whether, again, this is just a way to try to evade the requirements of the permitting program, whether this allows permitters to get away with something. She used that phrase several times, what's being gotten away with or what they're getting away with. Mr. Lin, again, focused on the fact that even though there are some effluents that are getting to the ocean here, the wells were constructed with encouragement and funding from the EPA. Again, that there are other state and federal regulations that are significant and that are provide appropriate limitations here. And again, in returning to the example of septic tanks, which is probably one of the more powerful arguments on the petitioner's side, he pointed to the fact that under the traceability rule, the traceability standard that the environmental plaintiffs are advocating for, you could do a trace or die study, similar to what was used here to establish pollutants from individual septic tanks. And in fact, he pointed to a specific study that he cited in the reply brief where that had been done. So he expressed concern about whether there was any limiting principle under the environmental plaintiffs' approach. So I think the oral argument really indicated a division here. Justice Thomas didn't ask any questions, but all of the other 8 justices did. I think on the petitioner's side, Justice Alito seemed to be strongly in their favor. I think Justices Kavanaugh and Gorsuch, it's a little harder to tell, but some of their questions seem to go that way in favor of the petitioner, the county. And then the Chief Justice I would put in that camp as well. Now, on the other side, I think Justice Kagan and Sotomayor were probably the strongest advocates going the other direction. Justice Ginsburg, it was a little harder to tell where she is thinking. She didn't ask as many questions here as in some other cases. Just looking at what she did ask, I think there's a good chance that she would probably be on the other side as well. Justice Breyer is one who I could see writing separately in this case. He seemed to be very taken with his proposed functional equivalent standard, where he would ask for a functional or set the standard as whether it is the functional equivalent of a discharge, and then just let the EPA, the federal agencies, set rules that decide the details. So if you're counting noses, I think there could well be 5 justices, assuming that Justice Thomas would vote with some of the other more conservative justices, that would be in favor of reversing the Ninth Circuit. 3 who would be kind of clearly in favor of adopting the Ninth Circuit or a similar kind of standard, and then maybe Justice Breyer writing separately. But of course, it's always perilous to try to read the tea leaves of the Supreme Court, and certainly sometimes they ask questions that aren't necessarily indicative of where they're thinking of going. If I had to make a prediction, I would say that there's probably majority here in favor of reversing the Ninth Circuit. But as Greg Easterbrook likes to say, all predictions wrong or your money back.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.